I'm Alastair Hudson. This is the introduction to the law on investment entities. I love this course. I find this course fascinating personally. What this course is about is the law on investment. That's the substantive law as it relates to investment, and also the regulation of investment, how we protect consumers and so on. But it's not just done through a straightforward analysis of financial conduct authority regulation and how we've derived those rules from the EU, although we do go through all of that good regulatory detail. It also looks at investment through the entities through which we invest. So we look at a lot of history, we look at where these entities have come from. Now this focuses a lot on English law and UK legal concepts as a result. But I think it's very important to understand where do these investment models come from, because that tells us what are the rights of the investor and what are the obligations of usually the financial institution that's selling that investment product. And then we come to think about how modern regulation has been grafted on top of that, because we are still using a lot of investment models that are centuries old. And I think there is a tendency in finance law scholarship to be focusing very much on the now, on the new, as though nothing is more than 3 years old. And I think that can be a great error. For example, with the recent financial crisis, if we'd looked back a little bit further in time, we would have learned a lot of the lessons we needed to know. The lessons that were learned at the time of the Glass-Steagall Act in New York, for example, at the end of the 1920s. If we'd learned some of those lessons from that crisis, at the end of the 1920s, if we'd borne those lessons in mind, if we'd learned from our history, we could have avoided a lot of what went wrong when we entered into an era of light touch regulation, of unregulated derivatives markets and so on and so forth. So this course is all about taking concepts that we know about as lawyers, trusts, companies, the rights of investors, the obligations of scheme managers. All of these kinds of ideas, which are very familiar legal concepts, are a way of understanding the way in which we conduct investment, the way in which we treat investment in the modern world. So, what's all this about? Well, the course divides into various segments. Let's start at the end. The fourth segment is a straightforward analysis of financial conduct authority regulation, particularly conduct of business regulation and financial promotion regulation that are based on the Markets in Financial Instruments Directive, which was created in the EU and implemented in the UK in November 2007. For example, conduct of business regulation requires that any financial institution dealing with its customer must classify the level of expertise of that customer. And the idea is that with market counterparties, you can treat them in a particular way which recognises they should be able to understand the risks for themselves, but you do that differently from, at the other end of the spectrum, retail customers who perhaps have no expertise at all in relation to financial markets or financial instruments. And the idea is you have to treat those two types of customer differently. MiFID also created important standards, such as the financial institution must act in the best interests of its client, that a financial institution must ensure best execution for its client, that a financial institution must act suitably in relation to its client. Suitability referring both to the suitability of the product for that particular client and also the way in which that client is sold that product. For example, that there must be communications which are fair, clear and not misleading. All of those things are now required of financial institutions. And so one of the things we'll think about a little bit in this course is, have we really changed contract law in relation to the sales of investments? Because what we seem to have done is to have imposed positive obligations on the financial institutions. Now, if we think about contract law, of course, certainly in this jurisdiction in England and Wales, the courts will never impose positive obligations on a contracting party if that contracting party has not voluntarily assumed those obligations. Whereas financial regulation does impose those positive obligations. So suddenly we see the investor as being in a privileged position in relation to contract law as compared to other areas of law. So something very important in there. But what the heart of this course is really all about, is thinking about in sections A, B and C, what are the entities through which we invest? And so what this course does is to begin with traditional concepts of the trust and the company, and is to go back to trust law and to company law and to ask, how do they work as investment models? Trusts, particularly through the Trustee Act 2000, imposes obligations on trustees, unless there's something to the contrary in the trust instrument, which requires those trustees to deal suitably with the investments, to diversify their investments, to take proper advice. Now, those concepts have all come from financial regulation at the time, particularly that concept of suitability I just mentioned. So it's very important, I think, to start thinking about what are the rights and obligations in trust law that go beyond those concepts that really have been culled from regulation. The proprietary rights of the beneficiary, the obligations of the trustee in relation to breach of trust. And then we compare that with companies, because the modern company grew out of contract law, particularly partnership law, and the trust. The early joint stock companies were situations in which the stock that was put to sea in the boats typically was held on trust for all of the people who had participated in providing that general stock, and then they were all partners. So we see all these traditional concepts put together, trust law and contract law, to create something new. Very creative. It doesn't need a legislative mind to do this. You know, these are private practitioners doing this. And this matures into the company after 1897 through Salomon. So then we start looking at shareholders and what rights they acquire. But we in this course will also then move on in section B to look at collective investment schemes, unit trusts and open-ended investment companies. Organised under the EU UCITS directive, we'll see that unit trusts are predicated on good old-fashioned trust law concepts, hence starting with trust law. Open-ended investment companies are predicated on company law concepts, except that with an open-ended investment company, when you want to withdraw your investment, you simply sell your shares back to the company, which ordinarily isn't allowed under company law. There's a special carve-out for open-ended investment companies to do that. Unit trusts similarly look very much like ordinary trusts, except there's this big regulatory architecture which governs how the consumer, the customer, ultimately is protected, and which also provides for the way in which a contract between the financial institution and the investor is to be organised in parallel with the trust. The fourth bit then of this course, section C, is communal investment schemes, where we look at other types of entity, often forgotten, friendly societies, cooperatives, credit unions, which have become more and more important in finance in recent years. Think about how microfinance is working around the world. They really are finding other ways of bringing financial services to ordinary citizens beyond the corporate context. How do we get other investment services and banking services to ordinary citizens? Answer, some very, very old ideas which come out of the 17th and 18th centuries often in this jurisdiction, friendly societies and cooperatives. There were working class solidarity associations where people pooled their money. And as in the 20th century more and more statutes were created to regularise how they should operate, they became very useful prototypes for providing financial services. So friendly societies now sell insurance more than anything else, whereas once they were about protecting striking mine workers from penury and whatever else. So we will look at the drift of where these entities came from, how they're used in the modern context, and how they're now regulated. The friendly society has gone from being something almost seditious in the 18th century to something which in the 21st is now regulated by the Financial Conduct Authority and actively promoted by government. So this is a course which is all about investment law, but we're going to come at it from a very different angle. We're not just going to look at it from the perspective of dry as dust regulations. We're going to look at this fascinating historical soil, and we're going to see the plants that grew out of that.